So I'm Sandy Pentland, his advisor. He came here a couple of years ago. What is it, 4 years now? And it was really complicated because, well, he'd done an undergraduate here. He'd then done a law degree and wasn't quite done with it because they had this year at the end we were supposed to do like a practicum type thing. And MIT doesn't understand that lawyers can actually get technical degrees. So we had to like cause all of the bureaucracies to not talk to each other so that they didn't know what was happening. But we got him in here also so he could do his PhD while he was finishing up his JD. And we have a really unusual combination here, which is technology, AI sorts of things, together with legal structure. And you know, from my point of view, this seems like a very obvious thing to do. Codex at Stanford has been doing a sort of a version of this for almost 40 years, but it's just not common. And I think it's going to be really transformative. And Robert has dove in and caused it to happen, and so I think we're going to see a lot of change. Take it away, Robert.
No applaud yet. Let me turn on the lab. Can the folks on Zoom hear me all right? I know it's, I'll just make sure I'm standing here. Yeah, perfect. Well, thank you for coming. I know it's an early morning defense. I appreciate it. And I guess this is it, right? I get to tell you what I've been doing all these years. And at a high level, I've tried to define, like use this thesis to define what computational law as like a research field is. And to me, there are three kind of key themes, and we'll come back to them over and over. Fundamentally, like using computation to understand how legal systems work, like analyzing legal systems, building tools to improve those systems, and then actually extending them by regulating in new sorts of ways. And it seems kind of prudent to go back in time a little bit and start with like a little bit of history. And so I think even though the term computational law was coined like 2005 by Mike Genezareth over at Stanford, I think at least in the US, the kind of origins go back at least 100 years. And it starts with people like Oliver Wendell Holmes, who argued that we should really be treating law not as like an art or something like that, but as a science. And the object of that science is to predict future decisions. And we should borrow tools from you know, the quantitative sciences, from economics, from statistics, to do that as well as possible. They didn't build technology, but they set this kind of philosophical foundation on which later generations would. And so then in the like mid-20th century, people said, well, we have logic, and that's like a great math concept, and ultimately, like, what is law? It's just a bunch of like if, then, else type statements. So maybe we can convert all of logic into law, all of law into logic, and apply it that way. And it didn't take long for people to then start building expert systems that would actually express that logic. So folks like Richard Susskind, who wrote his thesis in the 80s, did exactly that. And then a little while later, in the 1990s, this became something like more like a community, right? So we had the first international conference on AI and law. We had a journal on AI and law. And people started coming together. And so against this backdrop, it might be a little bit weird for me to say, oh, I want to define this discipline that people have been working on for like 100 years. But I think today is different in some really meaningful ways. And specifically, I think today is different because we have models that can handle the kind of substance of law directly, which is language, right? Like law works on the basis of language, and lo and behold, we have natural language processing. We have large language models. And so we can do things that we weren't able to do before. And those models can also handle the kind of inherent stochasticity, right? The law is not like always going to proceed the same way. It's a little bit naive to think that you can just have like a set of rules and those will always tell you what the outcome is. There's variability there. And the models that we have today can handle that kind of variability. The other thing they can do is they can take language and they can extract data. The average judicial opinion is something like 4,500 words long. It has lots of data that we'd love to do interesting work with. But we can't get at that data without some mechanism by which to extract it. And today's models can help us do that. And I think the last thing is much more recent. But the culture in the legal profession has changed. In the last 2 years, I think the legal profession has really woken up to the idea that, hey, computation might be a thing that we should be doing. And so suddenly there's this possibility to use computational tools and actually get practitioners to do so. I want to dig into like the themes a little bit more before I start telling you about the research. So the first theme, like I mentioned earlier, is analyzing legal systems, understanding how they really work, understanding how they're changing, and understanding what the key problems are. These legal systems are composed of, I think at a really broad level, two players. We have people who follow rules, which includes all of us who are bound by like the laws of the nation. We have law firms who are counseling their clients, as well as companies that are supposed to obey the laws. And we have judges whose job is mostly to apply the law. There are also people who make laws, right? Rule makers. So the obvious ones are kind of legislators and regulators. But we also have judges who, in some cases, are going to find something to be ambiguous and then have to fill in those gaps and kind of acting as quasi-legislators. And of course, we also have citizens who, through referenda and other democratic processes, engage in rulemaking. For both of these groups, I think computational law can offer something useful. On the kind of rule followers side, we can improve access to justice by building computational tools that make it easier to engage with the legal system. And I think those tools can also make the legal system more efficient, more effective, fairer, more equitable. For the rule makers, we can, on the one hand, provide better understanding of how technology actually works. And on the basis of this, we can create more nuanced, more effective technology regulation. And we can think of new ways to express regulation, right? Kind of computationally enabled regulatory approaches that might work better, especially when we're trying to govern algorithmic systems. So this is it. We'll come back to this a couple of times, but this is kind of my overview of what I think computational law is as a research field. And so over the course of the rest of this presentation, I'll dig into these things and explore them a little bit. So starting with analyzing legal systems, understanding them. Before we can understand them, I think I need to give you like a crash course in law. And this is my favorite case from law school. It was not presented like this, but I think it's a fun way to do it. Essentially, there was a Chamber of Commerce convention in Minnesota, and this was like 1954. And it completely went off the rails. So people got quite inebriated. They ended up bringing all sorts of animals to the hotel. Someone stabled a mule in the lobby. Someone else brought an alligator. I don't know where you find alligators in Minnesota, but someone brought an alligator to their hotel room. And ultimately, an object was thrown out of a window. It struck a passerby. And so the court, when that passerby sued the hotel, had to decide, well, is the hotel liable? And the way that they figured this out is they looked kind of far and wide into what are the prior legal decisions. Like, has any court ever encountered a case like this before? And it turned out that in New Jersey, there had been a case like this. And the New Jersey court said, well, if the hotel is aware that the guests are being dangerous in some way, then it needs to protect passerbys. And so in this case, the hotel clearly knew. I mean, there were all these animals. And so it violated its duty, and it acted negligently, and it's liable. And I think the key thing to notice here is that there is this kind of reasoning by analogy, and essentially you have this citation, right? This citation to a prior case. And if we take all those citations from all judicial opinions, we get something exciting. We get a network of citations. And we as kind of computer scientists and computational social scientists know what to do with networks. We can analyze them. We can do interesting things with them. And so I want to give you two examples of kind of legal network analysis we did that, again, relate to this theme of trying to understand how legal systems work. The first relates to law as a knowledge system as a whole, kind of studying it at a really high level. And the second one will dig into judicial behavior more specifically. So lots of people, including Dashan, who is on Zoom with us, have been studying the science of science, right? This big system of science, and we want to understand how it works, why certain publications take off, why others don't, why certain authors become successful late in their career, all these interesting questions about science, and they've made lots of insights. And when we compare law to science and also to patents, which is another kind of well-studied system, all of them rely on citations, but beyond that, they seem really dissimilar. Judges serve under a context of very strict hierarchies, right? You generally cannot disagree with the Supreme Court, no matter what you think, and that's not true of science, right? You can disagree with anyone you like. Judges are appointed by the, federal judges are appointed by the president, confirmed by the Senate. They serve for life. Most scientists, most inventors will come and go over their careers. Judges are generalists, and so They focus on all sorts of different cases, whereas for scientists, they specialize. And cases are randomly assigned. I think it would be interesting to consider if we had random assignment of publications to scientists and what that would look like. So clearly the systems are different. And so we wanted to understand all three systems from kind of this really high level. And most prior models of knowledge systems focus on individual publications. And what we added to this is we thought about the community kind of dynamics of knowledge. And we said, OK, your probability of being cited depends on like the inherent fitness of your paper. How good is your publication? How old is your publication? How successful has it been in the past? But also how close you are to other members of the community, which is kind of intuitive, right? If you're in an area that is experiencing lots of growth, lots of people are excited about it, of course you're going to be cited more than if you're off in the distance doing something people are less excited about. And so it turns out that across all three systems, law, science, and patents, this kind of community-driven model performs really well. And one of the things that it does really well at is predicting future breakthroughs or future successes. So this chart shows you our prediction about, we essentially train the model up to a certain point in time, and then we predict into the future. How successful are these publications going to be? And specifically, we're trying to pick publications that are going to be in the top quartile of citations. And we're getting high prediction accuracies across the board, somewhere between 40% for patents and more like 60 to 65% for law and science, which works better than kind of purely individual publication-focused models. And it's cool, I think, to me, to see that it works across all three systems, right? That the same model works in all three cases. And kind of from the academic perspective, what I think it shows us, which is kind of, to me, a beautiful result, is that like despite all these like ostensible differences between how the systems function, what the incentives are, all of that, like when humans come together to make knowledge, they seem to do it in the same sort of ways, and we can capture that. From a much more practical perspective, it is very useful to know which publication is going to be successful, right? Which area of science is going to take off, which patent is going to be valuable to your company, and for law, which legal disputes are going to give rise to most interest. We also use this model to understand phenomena that have been known in scientific knowledge systems more intuitively. And so one such phenomenon is the Sleeping Beauty, which is this idea that a publication might come out, experience no success initially, and then suddenly take off. And one way to understand it through this community-driven lens is to say, OK, well, if you initially are published, like this publication, I think it was on ferromagnetism in the late 1930s, if you're published and no one cares about ferromagnetism, you're not going to get cited. But then like the community can evolve, its interests can change, and folks can move into that direction, and then suddenly the publication takes off, and we can kind of see that nicely in a visual way. And so, one, we see Sleeping Beauties occurring in all three systems, but two, we now have an intuitive way of explaining them. So moving from kind of law as a system as a whole to something more specific, namely judges and their behavior. And I think given that most folks in the room aren't lawyers, you might kind of expect that a judge's job is to say, OK, these are the facts of the case. This is the relevant law. Let me apply one to the other and come to a result. And legal scholars agree that most cases are like this, right? So about 90%, that's like the consensus number, of cases essentially proceed by a judge applying the laws to the fact, and those cases are called easy by legal scholars, not by me. And there are also hard cases. And what's a hard case? A hard case is one where the law has run out, where you don't know what the correct answer is, and so the judge is going to have to rely on something different. That might be their philosophy, that might be their sense of right and wrong, that might be something else. But it should be the exception and not the rule. And we wanted to see if we could dig into that. Like, is this actually the exception and not the rule? And the way we did it is we identified what judges cited early in their careers. And then we built an ideology profile and embedding of those citations for each judge. And then we'll use those embeddings to predict their decisions in the future. And so if you think about it in the moment, like if you, there's no way that what a judge cited decades before should influence how they decide future cases. Like there's no link between these things. Cases are randomly assigned, times change. It really seems like there should be no connection. But what these early career citations can tell you maybe is how the judge thinks, right? Like who do they choose to highlight? What kind of precedent do they choose to rely upon, et cetera? And so it turns out that this works better than it ought to. So on the top, you can see just a distribution of the plaintiff win rate by judge. And you would expect this to be a binomial distribution, but it's not. You see kind of in red a number of judges who either systematically favor plaintiffs, favor the folks who are bringing the lawsuits, or systematically disfavor plaintiffs. And when we use our early career citations to predict what judges are going to do, we can see kind of consistent predictability. Even after applying statistical corrections, we see that for about 6 to 8% of judges, we can consistently predict across their careers. And if this was really the exception, right, if it was really the case that only 10% of cases are these easy cases, it shouldn't be possible for us to make these predictions. And so then, again, there's this kind of like big question, big picture, and then pragmatic takeaway. The big picture is that this is probably not ideal, right? This is not the way we want the legal system to work. And we've used a quantitative tool to analyze something that a lot of law review articles have been written on to gain some sort of insight, right? To understand like how many judges and what kinds of judges. On a kind of more pragmatic level, wouldn't it be nice to know before you go to court that that judge is never going to side with you? And you can then seek out alternative directions. And so it seems like this kind of work sheds light on multiple levels. So to summarize this little section, on the one hand, I showed you an example of modeling the evolution of legal systems as a whole, predicting breakthroughs. On the other, a really specific examples of modeling judicial behavior. And both of them, to me, are examples of using kind of more advanced computational techniques to do something akin to empirical legal research, understanding how legal systems work. Moving to the second kind of topic, chapter, improving the law. And here our focus is going to be on building tools that can help people navigate legal processes more effectively. And I think the kind of obvious, easy justification for doing this, easy motivation for doing this is access to justice. So in the United States, there's this organization called the Legal Services Corporation. They do an analysis of the access to justice gap. So every year they publish like how many Americans have a civil legal problem and don't have access to a lawyer. And the reality is that about 1 in 3 Americans have some civil legal issue every year. Most of them are small, right? It's a landlord who doesn't return a security deposit. It's a wrongful termination. Like these relatively small disputes, but still like they matter to people. And for most of these people, the idea of getting a lawyer is absurd, right? A lawyer costs $300 to $400 an hour at a minimum. And so for most of these kinds of disputes, it just doesn't make sense to hire a lawyer. And so to me, this is like the best motivation, right? Like this is what we should be doing research on. But we did an analysis of like a systematic literature review of legal natural language processing publications. And it seems like this is not what people are focusing on. So all the time you hear kind of the lack of technology in the law being blamed on lawyers. And I think that they carry their share of the blame. They have incentives like the billable hour. They bill by the hour. Why would they want to be more efficient? They're generally pretty risk averse as a group. But it also seems to be the case that the technologists are misaligned with the needs of legal practitioners. The analysis showed that they don't tend to publish together, so very rarely do we have lawyers on a team of computer scientists, nor do they even cite each other. Very rarely does like a legal NLP article even cite any law review pieces. And if you actually dig into like what people are focusing on, which is what the chart shows, the number one application is this thing called legal judgment prediction. And there are lots of kind of framings of this task. There are dozens of papers on it. But the high-level thing is that you take the facts from a judicial opinion and you try to predict what the outcome is going to be. And it kind of ignores the fact that when a judge is writing the facts in the judicial opinion, they know what the outcome is. So this is an exercise in sentiment analysis, not in legal reasoning, which is really unfortunate when you have really, really smart people spending their time on a task that might not be that helpful. And so what I tried to do is to try to think about tasks that would be helpful, right? Tasks that lawyers do every day, where we could empower people to do them either more efficiently with the help of a lawyer or do them by themselves. And one task that we already talked about earlier is legal research, right? And what we did in that space is we put together a data set, Leopard, which I think is a fun name, of essentially every time a judge quoted some other judge and the context in which that quotation occurred, right? So we went through every single published federal judicial opinion, pulled out these quotations to prior case law, pulled out the precedent, and what we got is a data set of 1 million unique passages in 14 million different contexts. And when we train a model on the 10,000 that occur most frequently, we'll talk about that in a second, we can get prediction accuracies of like 93% if the correct passage is among the top 10 predictions 93% of the time, which is good. Like that's pretty remarkable given like how big law is. The big challenge with this data set, and I think the reason we published it as a data set piece and not a methodology piece, is that it's a really long tail distribution. And so the vast majority of things are cited once or twice. And then a couple things are cited thousands of times. So it's very easy to make these predictions for the 10,000 most commonly cited things, and it gets increasingly difficult to make predictions as you kind of want to understand all of the law and be able to predict across all of case law. So while other academics are out there publishing and perishing, the Media Lab has a different motto. We demo or we die. And so I think this was like the second year of my PhD. Sandy had written to me, you should really like make a demo, something you can show people. And so I built this demo where we have an argument that is ingested by this model. And it will spit out these passages of case law, right? It's not generating these. It's just essentially ranking all of the possible case law by its relevance to the argument you're making. And then you can, of course, combine this. So the demo then got extended. You can combine this with modern large language models. Give them the argument you're trying to make and the passages that it should rely on. And it will happily generate a brief. And these briefs tend to be pretty good. We've run them by lots of lawyers, and we've compared them to legal briefs. And they're like generally viewed as a good starting point for a lawyer to actually do something with. One of the key things here is that lawyers are very nervous about hallucination. They're very nervous that the AI is going to come up with some case law that doesn't exist, and it's going to make them seem very silly in court. And this kind of approach doesn't suffer from hallucination generally, right? Because I can only give you case law that actually exists. I might give you case law that is less relevant to the task at hand, but I'm not going to come up with new case law. And so this is generally, I think, a really powerful approach. So again, to wrap up this section, I showed you two things. One is a more kind of perspective piece on access to justice being something that I think should be a normative goal for legal natural language processing, and then a specific example of that in assisting litigants in crafting arguments by predicting precedent. All right, on to the last chapter. So here, the interest is not so much on understanding legal systems or helping people navigate legal systems, but actually how we define laws themselves, right? And this is very similar to this like Larry Lessig idea of law as code, code as law. How do we take regulation and express it in different ways? And kind of more simply, but how do we make sure that we understand technology well enough to regulate in a sensible kind of way? And so starting with the second thing, understanding technology to regulate it in a sensible kind of way. In 2023, we worked on a perspective piece on generative AI, the art and science of generative AI. And we had this figure where we tried to come up with like, what are the biggest questions for generative AI and law? And the first one you see is about fair use. And this fair use question has gotten a lot of people really excited and has generated a lot of debate. So I'll try to summarize it for you. Essentially, the fair use doctrine is this idea that under certain circumstances, you can use a protected piece of work, something that has been copyrighted, without getting permission, without paying, because the way you're using it is far enough away from what the original was doing, and it's not going to influence the original, that it's fine, and it's kind of in the interest of us generating more art and more stuff for you to use it. And so courts have come up with these four tests, four-factor tests, to determine whether something is fair use. The first is the purpose and character of the use. The second is the nature of the protected work, the amount you're using, and then the effect on the market. So if we, and then people, when they talk about AI and copyright, including in the prior article, they'll kind of lump all training data together, right? They'll say, oh, well, AI is trained on all of the internet, or all training data is the same. But really, that's not the case, right? And if we understand kind of how AI is trained, and I think Tobin is going to tell us a lot more in his defense later today about how AI is trained, then we know that there's fine-tuning data and pre-training data, and those are fundamentally very different. And so it seems like the law should treat them differently. So if we go through these, fine-tuning data is data that was made specifically for the sole purpose of training AI, whereas pre-training data wasn't, right? No one's writing poems so that an AI can learn how to write better poetry. But people are out there creating and spending a lot of time and effort creating the best possible fine-tuning data sets. On that note, I think sometimes we think of data that computer scientists are creating as quantitative, factual, kind of not creative. But if you look at like how people are going through annotating these kinds of data sets, creating data set that is going to elicit the best possible performance from AI, there is a lot of creativity in those annotations. And that is creativity that the law is probably going to protect as copyrightable. Pre-training data obviously contains all sorts of things, from encyclopedias and news articles to really creative works like poetry, and so it really varies there. The amount used is also interesting. So fine-tuning data, you kind of use all of it. And it's also, you're using it further downstream of the model training, right? Like the impact of a given fine-tuning data set is likely to be higher on the finally trained model than any given piece of pre-training data. For pre-training data, it's really complicated, right? Because you could argue, well, the only thing the models are doing is they're learning linguistics, right? They're using all of this stuff to learn how language works, some facts, kind of broad stroke stuff. But we also know that models memorize whole passages, whole works, and so that makes us think maybe they're using the whole thing, and it's really a complicated question. And then finally, the effect on the market. So if I publish a pre-training data set, and I say there's a non-commercial license, and if you'd like to license this commercially, come to me and we can negotiate something. And you go ahead and you use it without my permission, well then obviously you're affecting the market for that data set. On the other hand, if you use a poem that someone's published to train an AI model, it's not as though that person was out there waiting for an AI company to buy their poem. They were waiting for other humans to buy the poem. On the other hand, if you succeed with your AI model and it creates really good poetry, then maybe there's this long-term effect on the market for poetry, right? Like maybe you're undermining your own market in the long term. So all that is to say, pre-training data is complicated, and lots of people are talking about it. But for fine-tuning, it seems like maybe fair use doesn't apply. And if fair use doesn't apply, then the licenses that people associate with fine-tuning data sets really matter. The problem is that we don't really understand these licenses. And so Shane's in the room, Shane and I, and lots of other people wanted to understand, like, where are these licenses coming from? What are they really? How do we resolve all the conflicts between the licenses? So we came up with this kind of complicated looking, and it was kind of complicated in practice, annotation flow to get the original data set licenses and annotate them by various criteria. And ultimately, one of the things that came out of this was an Explorer tool that would allow people to select the data sets that make sense for their application, not just in terms of licenses, but also all sorts of things related to the languages that are covered, the tasks that are focused on. I think one thing that is interesting to note is this OpenAI slider. So if a data set is created with the help of OpenAI, then the terms of OpenAI says you can't use OpenAI's service to compete with OpenAI. And so there's this interesting question about whether that's akin to a license or not. In any case, not only do we help people select data that makes sense for their use case, but we also give them lots of statistics about this data, who created it, where it's coming from. And all of this is relevant not just to like build the best models by understanding where your data is coming from, not only but also to kind of comply with all sorts of regulation on data provenance and data transparency. So these kinds of tools that are kind of quasi-legal, quasi-quantitative, I think are quite useful. Moving on from fine-tuning data to pre-training data, we did this analysis for different websites that are part of the Common Crawl, which is this massive data set of websites, where we looked at their robots.txt in terms of service files. And we found that after the various large language models were released, websites were taking steps to protect their content. And I think that this changed my thinking in a way, because I didn't think that the kind of whatever steps a content creator took to reduce AI, it didn't seem obvious that that would affect anything else. But what we see is that some of these restrictions aren't just AI exclusive, they apply to people. They undermine the openness of the web because it makes it harder not just for AI bots, but for everybody to access this content. And so there are these interesting unintended consequences, which again, only quantitative analysis can really surface. Finally, on this topic, we compared what kind of domains the pre-training data was focused on and what people were actually doing with large language models by looking at 1 million ChatGPT interaction logs. And this might be different now where these tools can search the web, and that raises all sorts of really difficult questions for copyright. But focusing on just like a model that is doing prediction and generation, we see that people don't generally use it to get their news, even though news is by far the largest component of the pre-training data. It makes sense, like the model is not up to date, why would you use it to get your news? And so there's this mismatch for copyright purposes between the data's purpose and the way you're using the data. And that mismatch probably weighs in favor of a fair use finding and really relates quite closely to the New York Times v. OpenAI lawsuit, where this is one of the things that is being argued about, right? Is OpenAI essentially taking the New York Times' data to compete with the New York Times? From a more technical perspective, this might also give us pause, because if we're training a model that is not used to generate newspaper articles, on newspaper articles, that might not be the best kind of training data. And again, this kind of like empirical, legal-inspired work can have these interesting implications, not just for lawyers, but kind of the community writ large. So here, I've given you a couple of examples of research that focuses on understanding technical systems in a way that allows us to regulate them better. Now I want to talk about how we might be able to regulate with technology. And so Sandy and I wrote this paper on regulation by design, the idea of embedding embedding regulatory objectives into technical systems. And this is, the picture you see here is of Elijah Otis. He was from Cabot, Vermont. He invented the passenger elevator. And no one wanted to get into Elijah's elevator. They were scared that they'll fall to their deaths. And so what he did is he went to the World's Fair in New York, and he stood on his elevator platform, and he cut the ropes, and nothing happened, because there were ratchets that as soon as the tension was released, they snapped into place and they stopped his fall. And so then, we all installed elevators. We literally built to newer heights. And this is like the most obvious thing to do. If you're engineering a system, make it so that when it fails, it fails in a safe way. Maybe we can do the same thing more broadly with not just safety, but other kinds of regulatory objectives. A related concept is this idea of legal dynamism. So if regulation by design is to build a car that can't go faster than the speed limit, then legal dynamism is the idea of making a speed limit that depends on how many cars are on the road, what the weather conditions are like, all these kinds of things. This is a terrible way of regulating humans. Imagine you're driving down the freeway and the speed limit changes every time a car merges on or off. But it is a great way of regulating algorithms that fundamentally don't really care about the kind of changing rules, and so we could adapt their behavior based on larger market conditions. And so that kind of foreshadows that it seems like these kind of novel regulatory approaches that maybe weren't well suited for human systems are going to become increasingly good solutions for AI. And this is especially the case because AI exists in such a fragmented market space, right? We have a couple of big players, and everybody else is wrapping their technology in various different ways. These are not fundamentally very large companies. We have lots of little tech companies, lots of individuals who are playing around with AI who are not well suited to implementing the 500-something pages of the EU AI Act and making sure they're compliant with it. And so we worry about stifling innovation. We also obviously worry about real AI harms. And so this seems to be a middle path, right? A way of embedding whatever objectives, whatever we worry about into the technology itself in a way that's really flexible and minimizes burden. So to wrap up this piece, there are two ways that I think computational law can help with regulation. On the one hand, by understanding laws better, and I gave you an example of understanding technical systems better to apply copyright law in a slightly more nuanced way, and actually enabling new regulatory approaches like regulation by design. So that kind of wraps up what I've been working on, and I want to spend a little bit of time talking about what I will be working on, what I want to be working on. Hiroshi is one of the professors here. When I started, I'm sure he doesn't remember, but when I started, he told us, a master's degree is about climbing a mountain, but a PhD is about building a mountain. And I don't know, that stuck with me. And I think that I'm not done building the mountain. And so I think there are some really exciting things on the horizon. The first one requires me to take a bit of a step back. So when I imagine like paradise or utopia or anything like that, I don't think it consists of going to contract negotiations, submitting to depositions, arguing before a tribunal, hiring a lawyer. Law is this like really beautiful, special thing because it allows society to function. But it exists because like society there's friction in society because humans aren't perfect. If humans were perfect, we probably wouldn't need lawyers. And so it will be hard for the legal profession to make an argument that in a world where AI can perform legal services better, we should still let humans do it because there's something beautiful about that. There are other professions where that makes sense, right? Like woodworking or teaching, where just having a human being there is fundamentally something special, and we should treasure that. Most aspects of legal practice don't seem to fall into that category. But there are some, right? I think being judged by another human being is something special. And human beings making rules for other humans is also special. And ceding that responsibility to technology seems problematic. Similarly, lawyers obviously give you legal information and advice, but they also counsel people through really difficult periods in their time, in their lives. And it seems like that piece of legal practice is important and not something we want to automate. And so I think there's a challenge to the legal profession to think about like what parts of this profession are actually resistant to technological change. What should we focus on in the future, both as like a firm that wants to make a profit, but also as a profession that is there to support society, and as law schools that are trying to teach this next generation. So that's a whole kind of can of worms, an interesting, I think, area of research. The second is a little bit more specific and pragmatic. And we've talked about this a little bit already, right? This idea of embedding regulatory safeguards into technology. Increasingly, AI models are becoming more flexible, and it's really easy to use an AI in a way that's high risk. The best example, I think, is the EU AI Act says that one high-risk application of AI is education. Anything related to education is high risk. How easy is it for a teacher to upload an essay and ask, what do you think of this essay? Suddenly, you've engaged in a high-risk application under the EU AI Act. You have a whole mountain of paperwork that you should be doing. That's not really feasible, right? And so one approach is to say, well, we won't let people do that, or we'll kind of make sure that the systems that they have access to can't do that. But maybe a more kind of hopeful approach is to say, well, maybe we can make the systems behave in a way that is compliant, right? That works. And to do that, the system has to detect, like, hey, I'm being used in a high-risk way, and then take steps to maintain compliance with regulatory requirements, maintain safety, put up guardrails. So say, for example, the teacher asked this, the system might respond, okay, well, first of all, we need to have a human in the loop. Will you be my human in the loop? Like, let's go back and forth on this together. Second, we need to do record keeping. So let me know where I can deposit my recommendations and make sure that they're stored for prosperity. Third, we need transparent models. So in the background, I'm going to make sure that I'm going to use a more transparent model than a more black box model. All these kinds of things could be part of this idea of agentic self-governance. Finally, the idea of legal ossification. So I've argued that it's a great thing for us to train AI models to predict precedent. And I've also told you that sometimes judges are faced with a hard decision where the law has run out and they need to kind of fill in the blanks. And so there's a problem here, because if we cement the law circa 2025 by training an AI model, like, where is this new precedent coming from? Like, who's going to make the law when it runs out? One option is we say, well, we're done making the law. But that's a problem, right? That's legal ossification, because it means that the law will stop evolving with societal changes. The other option is we say, well, the AI will make the law. But then back to the artfulness of the legal profession, I don't know if that's such a good idea. So this seems to me not a problem today, but eventually, as more and more of the legal profession relies on AI tools to help identify, it doesn't even have to completely cede to AI tools to identify precedent, but just to rely on them in part, there could be this risk of legal ossification. And the way to steer against that is to make sure that we understand how the law has evolved. So that's the first project I told you about. And make sure that we have safeguards in place that kind of guarantee the continued evolution of law. That's it. That's a PhD in 40 or so minutes. I told you about how we can use computational law to analyze legal systems, understand how they work, how we can build tools to actually help with legal practice, and then how we can think about new ways of regulating. And now a point of order, Sandy, do I do my acknowledgements now or later? How does this work? Now is fine? Now is fine? All right, perfect. OK. I have a lot of people in this room and on Zoom a debt of gratitude. So I'll start with you, Sandy. And you kind of took the wind out of my sails, but I'll say again, Sandy really loves bureaucracy. Like, Sandy gets up in the morning, and all he wants to do is file forms. And so I'm very grateful that when I came to you as like a Harvard Law School student with this like kind of crazy, wacky idea, like, we're going to create a new joint degree. We'll do it during a pandemic. That'll make things easier. You went for it. And I really appreciate that. That means a lot. And obviously, this wouldn't have been possible without you taking a chance. Next, I'd like to thank my committee, Gabriele, Dasha, and Daniela. You're not here with us in form, but you're here with us in spirit. And you are a group of really preeminent scholars, and I'm really grateful that you took the time to kind of mentor me and support me. And you are a group of people who are hard to schedule around, so I'm glad we found a time. Similarly, all of these papers were the result of collaborations with lots of folks around the world, and it's really kind of humbling that people will kind of listen to a junior scholar and get excited about law when they're computer scientists or computational social scientists. And so I'm really very grateful for all the folks that made this possible. One person on the research front, and a really close personal friend, is Sandro Lera, who's kind of been with me since the beginning as a research collaborator, who's pushed me. Similarly, people at Harvard Law School, David Wilkins, Martha Minow, Scott Westphal, have really pushed me and have been open to this weird combination. A little bit more personal now. The Media Lab is a magical place. It really is. It's magical because you can do this kind of cross-disciplinary research with nobody really standing in your way. It's magical because we do parties that involve us going out and retrieving crabs from the Boston Harbor and then writing short stories about them. And so I don't think I should list all the people, but I'm really grateful to all of you for making this a magical time. There are also non-Media Lab friends, some in the room, who've put up with me and who've listened to my research and who've let me submit some of these slides to PowerPoint parties. Thank you for giving me kind of a source of external perspective. Then there's my partner in crime, sitting front and center, who it looks like I married, but I didn't. Tobin, you've been there. You've been life coaching me through a dissertation. I really appreciate it. Thank you. And then mom and dad, who are on Zoom, and who've been cheerleading me for like 30 years. I really appreciate it. And finally, Sarah, who, as of December, I can call my fiance, which is exciting. And Sarah's parents and brother who came. But yeah, Sarah in particular, you've been a rock. So thank you. PhDs are hard, so it's nice to be loved. Yeah. Question time, right? Maybe come here so they can see.
So normally what we do is we have questions from the committee just to sort of start off, and then we open it up to you folks, and then we're going to chase you out while we debate his future, okay? So let me start as a member of the committee, okay? So you talked about having sort of regulation by design and dynamic. I like the road example. That was beautiful, right? But one of the things that is often forgotten in this sort of thing is that there's people in the system. So if the AI is changing things and the people are still like in the other mode, you get these incompatibilities. And a problem, for instance, with all these agentic systems is got all these things, moving stuff around the world, but what happens when they change things and suddenly the drugs that you expected for your health don't get to your place when you expected it, et cetera, et cetera? How do you mix people into this?
Yeah. I mean, I think the answer is and this is something that like this whole area of computational law has been really bad at, is actually doing experiments with people, right? Like understanding at small pilot scales, like what happens and running it, and how do people feel about it, right? Like how does it work? How does it interact with people? I think that's the scientific answer. I know it's not like a philosophical one, but like,
No,
I think that's the way to do it, right? Start small, work up from there.
That's why science has experiments. Yeah, okay. So law has science. Well, so Daniela, Dashwin.
I don't know if
Who, is everybody there?
Yes, hey. yes. I'm here.
Go for it, Daniela.
So that was a great talk, Robert. I have some kind of conceptual questions and then maybe some more detailed questions. And so I wonder if you can summarize for us what are all the computational contributions of the thesis. You have done such a wonderful job covering all the different aspects of computational laws. So, what do you think are your most important computational contributions?
Yeah, I think there are three kind of high-level categories. So the first is in the kind of computational social science space, where we've developed all sorts of methods, from like models for legal knowledge systems, models of judicial behavior, things like that, where we've used computation as a method, I think, in creative ways. The second kind of more pure CSE is we've built lots of data sets and published them and methodologies. I mean, especially in this space of legal precedent retrieval, these are mostly ACL type publications, and so I think those are kind of obviously computational. And then finally, I think the data provenance initiative work, which has mostly been published in computer science venues, is a computational contribution in the sense that I think it makes law accessible to computer scientists as something that they can understand as a constraint on their work. And it seems to me, I mean, this is like a whole kind of high-level discussion to have, but as we're not trying to make like very narrow technical contributions, but really like unlocking superpowers with AI is something you say. Things like evaluations become really important. And I think throughout this work, there are elements of it that are kind of very expert-driven evaluation type tasks that I think will become more important as time goes on. I hope that's a useful answer.
So actually, Robert, I do want to share with everyone that back in the day, before the advent of the chatbots, when I explained AI to people, I had a few canonical examples, and one was in law. And my example went like this: well, imagine if you didn't have to read an entire library of 1,000-page documents about previous cases, and you could actually get support from computation, from natural language processing, to identify the most relevant prior cases. So you have totally delivered on that. So thank you for for delivering on one of my dreams.
Oh.
But I have a more technical question, and one is about the publication citation work.
Uh-huh.
So I find it very interesting. I find the Sleeping Beauty very interesting. And I want to ask you what you think about the findings that Neil Thompson identified recently. So what he did, well, recently, like a couple of years ago, so he identified that if something appears in the Wikipedia, then the chances of citation are much higher than if it doesn't. He did this with science papers. But I imagine that there could be a similar phenomenon in the legal space. What do you think?
Yeah, there certainly is, and I think what it would be is there are two companies that essentially have a duopoly on legal research in the United States, and they are the main mechanism by which lawyers and judges access legal knowledge. And in addition to providing case access, they write these treatises. Like they'll hire lawyers to write a big book on like the current state of antitrust law. And I suspect that those would be very similar to kind of the Wikipedia of law. I also wonder, I mean, it's interesting because you wouldn't expect that scientists would go on Wikipedia to do like their research. So I wonder if it's causal or if there's a correlation in there somewhere. And so presumably the kinds of cases that make it into the news and the press, and like obviously Wikipedia as well, are the ones that have just taken off for other reasons already. But yeah, if you're asking me if there's a similar mechanism, I would suspect it's these legal practitioners' treatises. And we talked about openness very briefly, but it seems like insofar as like law is something that is for everybody, if it turns out that this is the case, that kind of these for-profit publications are what is driving the law in the background, that might give us pause as well.
Sounds good. One more quick question. Do you think by showing data about how judges make decisions, do you think you can change the behavior of judges?
Oh, this is a good question.
And not go to jail.
Yeah, I'm very so this publication, like there's been a lot of back and forth between myself, my co-author Sandro, and also the editor about should we reveal the judges' names, right? I could tell you the 6 to 8% is about 50 judges who are currently serving in the United States District Courts, whom we can really predict their decisions. We're also very, very good at predicting which of those judges are going to be kind of promoted to the appellate court. So we have an R-squared of like 25% for that. And I think so currently, you know, the data is going to be public upon publication, and so anyone can recreate it. We felt that it was a distraction from the actual academic work. Maybe sunlight is the best disinfectant here, but it's not clear. I mean, we're not telling them that they're being biased along like racial lines. It's something much more subtle. It's that they're allowing their ideology to influence their decisions more often than they ought to, where that number is not 0. It's just less frequently. So I don't know if this is the kind of behavior that a human can kind of change. I also don't know if it's kind of grounds for sanctioning a judge. So it's a really interesting question. And I don't know. I hope it does. But I also worry that, you know, I've presented this to legal audiences, and they're like, oh, what you're explaining here is essentially a strategy to find the most biased judges. That's what you've created. Because we will just turn this around. We will find the ones that are most predictable, most reliably predictable along the direction that we want, and then take advantage of that. So it is interesting to do work in this kind of space, especially now in 2025, where I think it matters a lot. Where I spend a lot of time thinking about like what is the impact going to be. Yeah.
Why don't we get some of the other committee?
Thank you, Daniela.
Yeah, thank you, Daniela.
Yeah, I just want to just make some comments and observations. I thought my first impression is this actually improved quite a bit since last time I saw the presentation, which was, you know, the proposal. You know, a lot of times I see the dissertations, you know, it's not so much different from the proposal, but I felt like for this one, the message is much sharper in the way you're presenting it. And sort of holistically, I'm seeing quite a bit of improvement in terms of how you think about these work. So kudos for that. I mean, this is really, really interesting to see how this is sort of taking shape. And then, you know, obviously I'm quite familiar with your first work, and it's really interesting work and really important. I think I want to highlight sort of when you think about computational, you know, I think these days is a lot about LLMs, and that's true, and that certainly has a huge amount of potential. But I think it's really interesting to see this dissertation that came along with different but quite complementary computational chops, because, you know, the first set of work I would say is really taking toolkits from statistical physics, which is where I come from, and you know, it's a network modeling, and build on layer on top of that network model with embeddings. And I think sort of if you look at a computational, even within computational social science, people manage to marry this kind of a two sets of methods, or embedding plus networks modeling. It remains to be a rare but very powerful combination, right? So that, I think that's something that you should highlight a little more, and you should feel very good about that work. It's really interesting. And now looking at your second line, the improving legal practice one, my impression is this actually quite is relevant to the fairness literature, right? If you think about Sandel, Monglan, Nathan, or like, you know, John Kleinberg line of work, where they look at the beta hat and y hat and sort of try to see a bias and predicting judge decisions. So now I'm actually seeing this is actually very relevant to that, and so it'll be good to actually highlight that and sort of building on that as part. But you're thinking a lot more about efficiency, effectiveness, less along the sort of the bias and fairness per se, but it's actually quite relevant. And then I think the LLM aspect is really the right time. I think the NLP for law, you know, it seems to me ideal playground. At the same time, when everything else applies, right? Because it's a high stake, and you know, this is not a space that you can allow for hallucination. And I think I really like to see your new work about the sort of regulations and how to think around this. And I think that's going to be more and more important. I think going in terms of your future work, I kept thinking about sort of how do you tap into sort of a multi-agent system where, sort of almost like an adversarial network between AI agents where one pushes the boundary of law and the other one try to sort of think about the boundary of the law. And maybe there's something interesting there, and seems like the LLMs these days, is getting there. So it's possible to actually do something like that. So it could be something interesting to consider going forward as well. But, that's a great job.
Thank you so much. Yeah.
Gabriella?
Yes, can you hear me?
Yes.
Yeah.
Yeah, great. First of all, I want to say really congratulations, Robert. I think that, so what strikes me, and I agree with what Dashna just said, that indeed I see here there's been an evolution in this work from last time we spoke, the committee together. And I see that all these different work streams are kind of coming together now. So I think this work now emerges and looks like really a much more mature piece of work where you haven't lost at the same time the variety of work streams that you've been busy on in the last few years. And maybe at the beginning they could have looked like a bit sort of scattered, but in the end, I think they're starting to connect with each other very nicely. So, and I think this is, from my perspective, really also a testament to your ability to really be across disciplines. And that's really the added value that I think you'll bring forward, you'll bring with you in your future professions, whatever you will engage with in sort of having this ability as a lawyer to really engage with the quantitative tools and to really sort of inform decisions and including policy choices on the basis of quantitative analysis. I think this is going to be really an added value, and I think this comes also from the type of work you've been doing during your PhD and engaging with different topics and different methodologies, and ultimately they really now come together. So as you can imagine, my interest lies primarily in the last bit, so the extending legislation part. As you know, I'm very focused on evidence-based policymaking. So I think your work on the part around informed technology policy, I think this is really crucial. And I think your work on the data provenance initiative shows that extremely valuable, extremely complex, but I think you need to actually unpack complexity first. So you need to deal with that complexity, which is something that sometimes, policymakers can do, but you need, therefore, the academic community, research community to do that. And then there is another additional layer, which is actually to simplify that complexity. So, and that's the next step, in my view. In order to be this type of research to be impactful, that needs to be digestible and simplified. And so that's one comment I had. And the second one, which also leads to a bit of a question. So on the technology-enabled lawmaking, that is crucial also going forward as we're dealing more and more with complex legislation, and to the extent, of course, we want to also legislate complex technology like AI. And I think I'm all for it. I think we need tools to actually also enable better enforcement and better implementation of the law. At the same time, I think we also, and that's where my question comes, I think, where maybe in the future we also need to start thinking about also how you can help and equip governments to really have also the, not just the ideas around, oh, we need technology to better have better enforcement, but also what are the actual equipment and tools and infrastructure that policymakers and governments need. I think this is not a trivial thing. One thing is, of course, developing designing the tools and having good tools, which is of course not obvious. But at the same time, you need to also overcome the obstacle around having governments being equipped to use those tools, and also having people in government being open to use those tools. Mm-hmm. So there is kind of a two-pronged question, which is around the infrastructure and the mindset component. So if there is anything you'd like to to say on that, that would be great.
I would suspect, so thank you, first of all, and I'll just focus on the question. There's so much else to talk about, but I would suspect that the way to do this is to kind of rely a little bit on private market forces, right? So if you take the EU AI Act, if someone made a proposal for, say, Article 10 on data quality, right, which says that as far as possible, training, validation, testing data should be free of errors and representative. That's hard to measure. It's hard to figure out what that is. If someone made a proposal of a technical system that would do that and presented it to Brussels and said, here's the system, I'd like to go sell it to people or make it available, and the commission could say, yes, that's good enough, that satisfies it. That seems like a way that a government could kind of outsource that responsibility. And maybe that system would be an open source system developed by a university, maybe it would be a private market system. It could also be the case that the government builds these tools directly. I would worry about which vendors they're relying on to do so, especially like smaller governments, and making sure that it's robust. And then finally, I think that we need to have incentives for interoperability, right? Because like there's not going to be European AI and American AI and Chinese AI, I think and hope. There'll be people who are going across jurisdictions, and that should be possible, even in a world where there are divergent legal standards. And so thinking about how to encourage governments to do that, I think is also part of this. Yeah.
You might look at California law SB 813, which is not law yet. But what that does is it says government should nominate not-for-profits to set standards, to be standard-setting entities for various parts of law with AI, and could switch occasionally. But so it's a different sort of outsourcing. Different sorts of problems. Let's go to the audience here. Okay. Thank you, guys.
Yeah, thanks so much.
I guess I'll stand up. Thanks, Robert, for a great talk. I guess my question is very high level. So it's the year 2050, and you have kind of created some law changes with kind of how you want, and you presented two cases. One is kind of the 90% of the cases that you talk about, and one's the kind of one that will set new precedent. How will that take place? If you could like forward simulate that. Thanks.
I think like one easy resolution is like you say, okay, like for various reasons we want to have AIs in judging. It's more efficient, it's easier. And you just have a human appellate option, right? And you create some interesting incentives so that like not every case is appealed by saying like, well, if you appeal, it's going to cost you $1,000 and the other side will pay if they lose or something like that, right? And so you only appeal if you think you have a decent shot at winning. Something like that, which we already kind of have. And then, yeah, like it's likely that these kinds of complex questions are going to be settled by higher courts. That is, when there's real ambiguity, people are more likely to appeal. There's lots of like law and economics type literature on that. And so that seems like an easy way to kind of say, okay, the simple stuff is fine to automate. The moment it becomes binding, we want to have a human. The other thing to say though is like, I don't know what AI looks like in 2050. And I could totally imagine that there would be people who said, I'm perfectly comfortable with AIs making laws for me. Maybe they'll be more consistent. I don't know. It seems like a kind of scary world to me, but.
So a lot of the discussion has to do with, that I see, has to do with evidence-driven law. So it's much more law that is driven by actual facts and experimentation and things like that, which is a sort of a dialogue between machine things and human things. And the other thing that you already see today is arbitration. Arbitration is an increasingly large part of cases, right? And those are not, it's not the judge, it's a local person usually, but sometimes it could be a machine to be able to decide things. And you might have conditional arbitration where, here's the arbitration, and if you really, really don't like it, then you pay the extra $1,000 or whatever, and you go to dispute it. So those are visions that I see people talking about. Who else has she has the microphone.
Thanks for the presentation, Rob. Great slides.
Thank you, Nana, for helping me make them.
So my question was on the ideological bias and the predictability of rulings. So I'm not a legal expert, so I actually found it interesting to me, or kind of new to me, that this discouraging of the application of a judge's ideology in their, which like makes sense to prevent certain biases, but something that like how do you differentiate that from like just applying expertise? But I'm curious. It's because it seems in recent times with like certain rulings by the Supreme Court that a lot of judges are, particular Supreme Court justices, are under scrutiny for applying their own ideological biases, morality, religious beliefs to recent rulings. So I'm curious how you see that your findings being applied in a time where it seems that certain populations don't necessarily see a problem with that, and we might be moving towards a world where those lines are increasingly more and more blurred.
Big question. No, thank you. So one thing I should have made clear in the talk is that we were focusing on district court judges, so like the lowest level of the federal system, where you would think that the types of disputes would be more run-of-the-mill, where there would be less room for ideology because, like, okay, these are disputes that should be pretty clear-cut, and yet we see some judges who are kind of relying on their idiosyncrasies a lot more. You would expect that, like, it's more likely that a case that makes it to the Supreme Court is one where the law has run out. Otherwise, like, why are we there, right? So the Supreme Court is much more likely to be in this kind of quasi-legislative function. And in that situation, they have a host of tools that they can use to try to figure out how to fill in those gaps, right? They can look at the history of like when a law was passed and understand the context. They can apply textualism, like what do these words really mean? There's all these things, but even after you've applied those, right, all these like canons of construction and statutory interpretation and stuff, like you can still run out. And like at some point, you're kind of left with like, okay, I'm a human being and I live in a world of other humans and I want to figure out like what is the best rule for us as humans to live together. And if you're religious or you have a certain philosophy or a certain perspective on life, like it's hard to abstract that away. And I don't know if that's necessarily entirely the expectation or even like a possibility, because if we want that, then like maybe we really should just like leave it to machines to do. I think the hope is that like that reflects like what is best for society. So like as long as the people who are on the Supreme Court are the right people, then like presumably they can kind of represent. But yeah, I mean, nothing I say, no research I do can like fix or address that kind of thing. I think what's interesting to me is that this kind of work can allow us to analyze all judges in a way that like people focused on the Supreme Court, but most people aren't going to be before the Supreme Court. And I think casting the wider net can reveal new things that are important. Yeah.
Robert, on an early slide, you spotlight two, if you will, users of the law or engagers with of law, the rule followers and the rule makers. I'm particularly interested in a missing third category, the rule breakers, and the role of creative criminality in pushing the law's limits. And of course, there's the judicial and the legislative path to patching those. But in exploring this sort of simulation of future law, is there a role for sort of computational criminality?
Sure there is, right? I mean, I mentioned this with the prior thing, right? Like, if you can measure all the judges, you know, who are over-relying on something external, might be biased in some way, there's one way to frame that as like, okay, so we'll make the judiciary better. Or you can just say the other way around and say, well, we'll make it worse, right? And we'll take advantage of these trends. So, yeah, totally.
Can you, what I'm getting at is, can you explore in an anticipatory fashion the weaknesses in the code, in the law?
And I think that's something that Darshan mentioned, right? This kind of adversarial, like if we can get to a point where we can model legal systems with some degree of accuracy, then we could do adversarial testing. We could figure out how might someone try to flaunt the laws and what can we do proactively. Sure, yeah. And I think this idea of legal simulation still seems like a little bit gimmicky, right? But I think we'll get there, where you could have like a wide enough swath of different actors simulated with sufficient accuracy that it makes sense, and you could see what happens, and it could be really quite interesting.
It's interesting to think about the whole crypto space as an example of this. Right? Is that illegal? Well, if it were conventional finance, usually, but it's not, and so there's this claim that it's outside, and there's a big debate that's been going on for 15 years or more, right? And AI, of course, is the same type of thing.
Sandy, I think Daniela needs to be at the White House in 15 minutes.
Okay.
So should we pause the questions?
Yeah, so-
Switch to the committee, is that okay?
Well, let's do it this way. Unless somebody has like a really burning question, we'll bring this to an end. And you guys have to leave so we can grill him, and then Daniela can get to the White House, and the world will be happy.
You can ask me
Okay.
questions after.
Yeah, you could corner him and ask questions. That's right, yeah.